Okay, so good morning to everyone that's here present with us today, and all the other participants that will see us later. It's not, on a common trend nowadays. I'd like to start by thanking all the participants, all the professors here, Professor Nada de Araújo, Clo Falice, and Margot Bruinks. I don't know if I'm saying it correctly, I hope so. And also Professor Nicolas Nord, and of course, our host and our beloved Professor Maria Rosa Loula. We have a very, very interesting event today of utmost importance. We have, so Professor Maria Rosa has been conducting these events for a while now. They have been a great success, and it's also part of a trend that we are trying to develop in our Institute of Internationalization. So we Brazilians are known to be open to other cultures, to other languages, and but we don't have a very strong culture of developing so our law academia in other languages, and also not in English. And that's a major point that we're trying to change right now in EDP, and Professor Maria Rosa is one of our most important developers of this trend. So I won't take any time of you anymore, so I'm very interested in everything that's going to be discussed right now. I'm certain that a lot of our students and other participants will also learn a lot from today. So I thank everyone again, and I will stay here with you. And if I can be of any help, please contact me. I'm here. And thanks again, Professor Maria Rosa, and all other professors that took time to be with us today. Thank you very much.
Thank you, Dean Schertel. We are very honored with your presence. It's really a pleasure to have you here with us in our unfortunately last meeting. From the ICCS point of view, I think we've gone a long way discussing the implementation and the possible implications of the conventions. We've had on our first day someone from the Attorney General's office, the head of the International Department. The second meeting, we had a member of the Central Authority, the Brazilian Central Authority. Today, along with our colleagues from the ICCS, we will be hearing from my PhD professor, Professor Nadia de Araújo, someone that in Brazil is very known, and out of Brazil also, for her work with the Hague Conventions, for her work with private international law and civil procedure. And we'll be delighted to hear her from the point of view, not only from the academic point of view, but also from the practitioner. Someone that will be adding today to our insights. So with no further ado, I'll give the floor to Professor Nord. As we've been doing, he'll be presenting his team. And after his speech, Professor Nadia will have the floor to argue and provoke. Thank you.
Professor Maria Rosa, I don't know if I made a mistake and I forgot to introduce Professor Nada de Araújo. I don't know if I forgot to mention her name. If I did, so I'm very sorry about that, because I started by, so I don't know the correct order, but I tried, so woman and the foreigners. But I'm sorry if I forget you. I just, I don't know if Professor Maria Rosa did so, but I heard a little bit of, not a critic tone, not a critic, but a very friendly tone of her. So I just let me say, if I forget to mention you or anyone else, it's of course a mistake of my part, and I'm really sorry about that.
No, I guess you haven't. We are very informal here.
Okay.
So,
sorry.
and Professor Nadia will have the chance to introduce herself too, because I think that's very interesting for her to present her work in the international arena. So we'll get there.
Okay.
We're fine.
Thanks.
Thank you.
Okay.
Thank you. Thank you very much. It's great to be with you today again after the two first sessions. I will just introduce two persons who are representing Belgium. First on my screen, Mrs. Margot Bruynanx, and the second on my screen is Chloé Fallis. And I remember that Chloé Fallis speaks Portuguese very well. So if later you have some questions, you may raise them in Portuguese and she will be perfectly able to answer you directly without any translation or use of English.
Yes, no problem.
So I will just share my PPT again. I hope you can see it. Don't know if it works. Oh. Is it working for you?
No, Professor Nord, not. Yes, no, yeah.
Yeah. Okay, because we have tried with Emily just a few minutes before and everything went well. Fine for you? Great. So we're gonna discuss today the questions about two different facets. Last week, we studied the questions of circulation of acts, and this is what ICCS is very famous for. Today, to give you a clear overview of all the activities of the ICCS, the focus will be on two different questions. The first one will be the question of harmonization of personal and family law, and the second one will be the question of state cooperation. Just to show you that, of course, circulation of Civil Statutes Act is very important, but it's not the only concern for our organization. The first topic will be harmonization of personal and family law. Personal law, family law, generally speaking. So we must keep in mind that family law especially is not only concerning marriage, of course. The scope of the different instruments that we're going to mention, that we're going to study today is very wide. Of course, it's impossible to study all the instruments in detail. It's going to be impossible because there are too many instruments. We cannot study all of them and discuss all the different rules contained in such conventions. I will try to give you some examples, maybe the most significant ones. I hope at least that they will be significant for you. And I will try to give you different facets, again, of these questions of harmonization of personal and family law. The first level of harmonization. The first level is harmonization of conflict of law rules. It's very logical. We are in international situations. We are faced with these questions. And so the best way to deal with these questions is, of course, to have an harmonization directly of the conflict of law rules. The objective of the ICCS, of the International Commission on Civil Statutes, is not to compete with the Hague Conference, of course. It wouldn't make sense. The idea is to fill gaps, especially when there is a direct link with civil statutes. Sometimes it may happen we don't have any convention at all. Nobody is interested in a question, crucial one, maybe sometimes very technical one. It will concern civil statutes. It means that ICCS has taken some opportunities and has concluded important conventions about harmonization of conflict of law rules. I will try to give you some examples. First convention concerning harmonization of conflict of law rules. It's already an old convention, number 12, on legitimation by marriage. And you see the date, signed at Rome in 1917. The main goal, of course, it's very easy to guess just by reading the title of the convention, is to facilitate legitimation. Facilitate legitimation, and it's very easy to explain. In many countries, it is still the best regime. So to be legitimated is the best solution, both for the parents and for the children. Legitimation is always more satisfactory, and it gives access to the best rules in many different countries. The main rules, you have the key rule just under your eyes, Article 1st of that convention, where under the domestic law provisions of the national law of the father or mother, their marriage has the effect of legitimating a natural child. Such legitimation shall be valid in the contracting states. We see that first, nationality is used, application of the national law. It means that according to the member states, it is the most significant element, and it will permit to identify law applicable due to the strong link with the situation. First point. Second point, you see alternativity is used. National law of the mother or of the father. It is used, of course, to promote the results, to permit the legitimation. So no problem about it. And you see in paragraph 2 that the origin of the legitimation doesn't matter. Celebration of marriage per se, and also legitimations established subsequently by a judicial decision. So the origin is not a concern. What is important is to have a legitimation by one of these two laws. Of course, and as always in the different ICCS conventions, there is an idea to find a kind of balance between the interests of the different states concerned. This is why in Article 2 of that convention, you have a possibility for the different contracting states to reserve the right to refuse to treat the legitimation as valid. And you have different situations mentioned directly in that article. So possibility for a state to ratify that convention, say, I want to apply these rules, but to say, I don't agree with such situation. I want to protect my own policy, my own interests. I will refuse legitimation in such a situation. So possibility, you see, to have a kind of variation concerning one particular state. And the last sentence, this right may not be exercised in cases where the domestic law of the state concerned would not, here you see it clearly, prevent such legitimation. It means an idea of equal treatments between national and international situations. So a clear balance must be found here concerning these questions of legitimation. And maybe the most interesting point here in that convention is Article 3. You know that generally speaking, you can always use public policy when a conflict of law or rule is created. This time, Article 3, recognition of the validity of a legitimation that complies with the domestic law provisions of the national law of the father or of the mother may not be refused, even on grounds of public policy in circumstances other than those set out in Article 2. It means that there is a clear restriction of the use of the exception of public policy. A desire to make the mechanism truly effective. Very important to notice here. An example of restriction of the use of public policy. It doesn't happen very often, even in international conventions, and this is one of the most famous examples. So real commitment for the different states concerned by this convention. First example. Second example, other convention, number 19, this time, on the law applicable to surnames and forenames, signed at Munich in 1980, this time. The main goal of that convention is to overcome the diversity of national rules of private international law. You see it, we have discussed about that problem during the first session. Very often, the problem is diversity. Diversity because some states are using the criterion of domicile, others are using nationality, some states are using the habitual residence. The problem is, of course, that each time another law may be designated. And so there will be no continuity for the name of the persons concerned. I think some of you have experienced it. Some Brazilian persons are directly concerned when they come to Europe. Their name will not be the same in Europe and in Brazil. Here, the idea is then to overcome that diversity, to allow a real continuity for the persons concerned, for them to have the same name and the same surname in the different contracting states. It's very important, of course, for you and me when we are traveling, when we decide to live in another country. That's true. It's also very important for the authorities concerned. Authorities concerned because it will be much more easy for them to identify the different persons concerned. The main rules, again, nationality prevails. You see it in Article 1, the surnames and forenames of a person shall be determined by the law of the state of which he or she is a national. It is considered, again, as the best elements, the most significant one in that field, for especially some cultural reasons, strongly with the country of nationality. Just to be clear, what does it exactly mean to avoid some misunderstandings? Law of the nationality of the person concerned means both domestic substantive law, but also conflict of law rules. So it means that if the French law is applicable as a result of the application of that article, French law as a whole will be applicable. If, according to the French conflict of law rules, a foreign law must be applicable, then you will have to use that foreign law. It's a kind of delegation to that law of the nationality of the person concerned. So very important here, that delegation used by Article 1st of that convention. The scope of application, again, is very wide, especially because there is no restriction concerning the law applicable. So it is not only applicable to the citizens of the different contracting states. No, it will be applied to all the persons concerned when there is a problem with the authorities of at least one contracting state. Article 2, the law designated by this convention shall apply even if it's the law of a state which is not a contracting state. So even now, if you have a problem as a Brazilian citizen, if you are faced with an authority of a contracting state, you might invoke that convention. It is always possible. And we find, again, a problem that we mentioned during the first session. I think you remember the origin of ICCS. Genesis of ICCS, always practical concerns must be integrated in our reasoning. And Article 5 is a clear example of such a situation. Why? Because sometimes, of course, sometimes it might be difficult to identify the content of the foreign law, which is applicable due to the conflict of law rule that we have mentioned just before. Article 5 gives you a solution. If civil registers who are drawing up a record cannot obtain information about the law applicable to the determination of the surnames and forenames of the person concerned, they shall apply their domestic law and so inform the authority to which they are answerable. It means that, of course, the best solution is always to apply, to use the law of the nationality of the person concerned. But if it's too difficult to identify the content of that foreign law, then it will be possible for the civil registers to use their own domestic law. A kind of compromise between the different solutions. It must not be too difficult for the civil registers. With paragraph 2, it must be possible for a record dues drawn up to be rectified by means of a procedure free of charge. It means that if the content of the foreign law is proved later, then rectification will always be possible. So you see, again, a kind of balance found by such a convention. Third example is the convention number 7. Convention number 7 to facilitate the celebration of marriage abroad. Again, the title gives you some clues to identifying the main goal of that convention. It is to avoid complex administrative procedures in a country other than that of the place of celebration. It means what? It means and of course it is very useful during the pandemic. It means to avoid unnecessary travel to obtain some administrative derogations, especially. You will not have to travel abroad to obtain some administrative documents. Article 1st is, again, the key rule of that convention. It can be considered as a kind of delegation of competence for dispensations concerning celebration of marriage, where the marriage of a national of one of the contracting states is to be celebrated in the territory of another one in which he or she habitually resides. The competent authorities of the country of the celebration may, in the cases and subject to the conditions provided by the personal law of the future spouse, grant him or her dispensation from impediments to marriage prescribed by that law. So the principle is application of the national law of the persons concerned. But sometimes you have some conditions which are not completely mandatory. Possibility to obtain dispensation. It might be difficult for these persons who are concerned to come back to their national state in order to obtain such documents. Then, according to Article 1st, you have a possibility of delegation. The authorities of the place of celebration have also competence to issue such documents. So very easy for the persons concerned by the marriage to obtain these dispensations. Then in Article 2, you will find some procedural questions. Procedural questions, but they're also very important in practice, of course. At the place of celebration, so in the country where the marriage is to be celebrated, the authorities empowered to grant such dispensations that we've seen just before shall be those which are empowered under the domestic law of that country to grant the same dispensations to its nationals. It means that they know exactly what they're doing. They're familiar with such questions. They know exactly how to deal with that problem of dispensation. In a situation in which it doesn't exist, paragraph 2, a country whose law makes no provision for such dispensations for its own nationals may empower one of its authorities to grant them. Then you may have a special habilitation for such questions. It will always be possible. So you see here, again, a kind of balance which is found in Article 2. And remember, there is no restrictions for the authority of the state of nationality. It's a delegation, but the authorities of the state of nationality of the spouses, they still keep their own competence. According to Article 3, the convention shall not affect the power of such authorities. They are still competent, they can still issue such an authorization. So it's an addition of competence. This means that it's very favorable for the persons who are concerned. I can decide if the celebration is in another country than the one of my nationality. I can decide to obtain that dispensation in the state of the place of celebration or in my national state. It's an option, so it's up to me to make such a choice. Article 3 of that convention. That was the first level concerning harmonization. Let's see now harmonization of substantive law. So a different level, this time national, oh, there is a mistake on the PPT, I'm very sorry for that. Harmonization of substantive law. Some examples, again, of conventions concerned by that harmonization of substantive law. The first example, and it's a problem that we already have identified, Convention number 14 on the recording of surnames and forenames in civil statutes registers. We know it. There is a problem concerning continuity of the name, so both surnames and forenames. We've seen before that there is already a unification concerning the conflict of law rule. Now, on a different level, there is also an harmonization. The idea is always the same. The indication of surnames and forenames must be the same in all the contracting states, in all civil statutes documents that concern the same person, because it facilitates the identification of the person concerned and also the daily life of that person. Exactly the same concern as for the unification of conflict of law rules. But the method, of course, will be completely different. This time, according to Article 1st, the convention applies to the recording in civil statutes registers of the surnames and forenames of all persons, whatever their nationality. It shall not affect the application of the rules of law in force in the contracting states concerning the determination of surnames and forenames, and no prejudice changes legally made in surnames and forenames can always be changed after the records and documents produced with a view to the making of a further record were drawn up. So the scope of application, you see, is again very wide. It doesn't depend on your nationality. Even if you're not a national of a contracting state, you may obtain the benefits of that convention. In Article 2, the first rule is applicable when the same characters are used between the two states concerned. The general idea, you see it, is that surnames and forenames shall be reproduced literally. Here you see where a record is to be made in a civil statutes register by an authority of a contracting state, and there is produced for that purpose a copy or extract from a civil statutes record or some other document that shows the surname and forenames in the same characters as those used in the language in which the record is to be made, those surnames and forenames shall be reproduced literally, without alteration, without translation. But this time it will be very easy to deal with such a question. Your name will be exactly the same in the two different states. So in Brazil and in Germany, it will be exactly the same surname, the same forename. No alteration, no translation. Very easy to understand. Then, according to Article 3, very often the problem comes from the use of different characters. For example, in relations between Brazil and Russia. This time it might be a problem to use such foreign characters. They are not the same, and you have to use your own characters in order to register the name. This time, the solution, of course, must be different. Surnames and forenames, they shall be reproduced as far as possible by transliteration, without being translated. Transliteration will be used. You cannot use the foreign characters, you will have to use transliteration. And of course, it is clearly mentioned if there are standards recommended by the International Organization for Standardization, they shall be applied. So here you have clear guidelines concerning such situations. And of course, always keep in mind that multilingual forms that we have mentioned last time, they might always be used in such circumstances. It will be very easy for you to understand the question, the act coming from another contracting state, especially by using convention number 60. Article 5, then. Article 5, there is no restriction for the authority of the state of nationality. Again, it means what, Article 5, unless domestic law otherwise provides, persons who have no surname or whose surname is unknown shall be designated in any record made in a civil statutes register by an authority of a contracting state, of course, by their forenames only. And if they have no forenames, or if these two are unknown, they shall be designated in the record by the name by which they are commonly known. So a material solution, again, because you have some practical concerns, some practical problems. Sometimes, very often it happens in France, you have persons coming from India and they have only a full name, but they don't have a surname. How can we deal with that problem? Article 5 gives you directly an answer. You know exactly what to do in such circumstances. And the rule will be the same in all the different contracting states. So no need to add another name to that person. You know exactly what to do, and it will be possible to have a clear registration according to Article 5. That person will be clearly identified. Then, other example, second example of unification. A very ambitious convention, convention number 15, introducing an international family record book convention signed at Paris in 1974. It's another method used with the creation of that international family record book. Registration in any of the contracting states of the civil statutes event concerning a family is the aim. So it will be very easy for a person to have a registration of the different events in the same record book. If something happens in one contracting state, it will be very easy to obtain the mention in that record book. Very important. It allows the authorities of the host states to know exactly the composition of a family and to complete the identity of the persons who come to live in their territory, to know exactly who is living in their territory. So it's very easy to deal with for the persons concerned. It's also very important for the authorities. I know that even if I'm French, I will go to live in Spain. I don't need to come back to France to obtain a mention in that record book. I can obtain directly the different mentions of all the events happening in Spain directly by the Spanish authorities. And it will be also very interesting for these Spanish authorities because they will know exactly who lives on their territory. I'll try to show you the example again. I will try to show you how it works. So don't worry, I'm just trying to stop and I will reconnect. I want to show you the model used in the convention. So the model of that record book. You have it in the annex of the convention. It's always the same system, you know, the multilingual form. I hope you can see it. So you have it in the annex here. So the same system, you have the different mentions translated in different languages. So very easy to understand. And you have the model form here. So the main page concerning, here it is in French, the extract of the marriage act. So everything is going to be detailed. You have some numbers. You see it on the screen, number 1, 2, and goes very far. And then if you go on the last page, you will find, you see, each time the translation. So you know that number 1 means the country. You know that number 5 concern the husbands. You know that number 6 concerns the wife, etc., etc. So very easy to deal with that record book. It will be, it means an easy access for the authorities of the different contracting states without the language obstacle. You will have an access, you will understand a record book coming from another contracting state without any problem. So always the same system as the one we have mentioned last week concerning Convention 16, Convention 34. I will come back to my presentation if you don't mind. So registration, just have to click again in any of the countries concerned. And you have seen this plurilingual model form that exists. So we are trying to add different methods to facilitate the life of the persons concerned and to facilitate also the work of the authorities of the different contracting states. Article 1, very important rule. The civil register shall hand to the spouses on the occasion of their marriage that international family record. And it means also that no family record booklet of a different design may be issued. So there is a monopoly this time for that international family record book. The aim, very easy, is to retrace the events of family life according to Article 2. They shall be entered in that international family record booklets. So a permanent actualization of what's happening in the family. It means that even if you're not in your national country, even if you're living abroad, you will be able to obtain new matches. All the different events will be concerned. Birth of a child, for example, death of a spouse, they will be mentioned in that book. And there is also leeway for the authorities of the different contracting states. So it means that it's very flexible because other informations peculiar to each contracting state may also be shown in a space provided for that purpose in the model that we have seen just before. Then the third and last example concerning harmonization, very quickly, is the convention number 13 to reduce the number of cases of statelessness. Very important convention. Why? Because it's the result of a cooperation with the UN Refugee Agency. Again, the goal appears in the title itself. Reduce the number of cases of statelessness. The key rule, Article 1st, a child whose mother holds the nationality of a contracting state shall acquire that nationality at birth if he or she would otherwise have been stateless. Solution of Article 1st of that convention. It's the main rule. It's can be considered as the best solution. Why? Because the mother is often easier to identify than the father. So very often you will find a solution due to the nationality of the mother, even if the conditions of the domestic law concerned, if these conditions are not fulfilled. The child will obtain the nationality of the mother to avoid a situation of statelessness. It's a very important rule. Specificity, and this is why the cooperation with the UN agency was very important. Specificity of the situation of the refugees. According to Article 2, the child of a father having refugee statutes shall be deemed not to hold the father's nationality. Of course, the situation of the persons who have the statutes of refugees is very specific. So it's a concrete approach because it wouldn't be a good solution for the child to get the nationality of his father in such circumstances. So you see, concrete approach, again, of kind of balance in such circumstances. Then the second part, concerning this time, state cooperation. I will give you again some examples of state cooperation in the frame of ICCS. Circulation of acts is crucial, but sometimes we need a more dynamic approach. It is necessary. We need to facilitate circulation of acts, but we need also circulation of informations concerning the persons. This is why several conventions have been concluded. The first one, a very old one, but very efficient also, is Convention number 3 on the international exchange of information relating to civil statutes. The problem here is easy to identify. The problem is that we need a cooperation between national authorities who have some information about persons. So the convention tries to initiate mutual aid and cooperation between the contracting states in order especially to avoid contradictions between the acts registered in different states. As a civil register, I have some informations it would be good for me to send these informations to another contracting state directly concerned by the situation. And that's the idea of the key rule of Article 1st of the Convention. All civil registers performing their duties in the territory of one of the contracting states must, it's an obligation, when making or transcribing a record of marriage or of death, give notice thereof to the civil register for the place of birth of each spouse or of the deceased. Of course, if that place is situated in the territory of one of the other contracting states. I have a very important information. I will have to send that information to another authority in another contracting state. We are not waiting for the persons concerned to deal with that question. We will do it directly as a national authority. Same system, Article 2, we have a system of models appended to the convention, and the notice shall be set out in accordance with such plurilingual models, of course, again. And in Article 2, also a very important rule, direct communication between the civil registers. Direct communication within 8 days of the making or transcription of the record. That information must be sent to the other authority concerned. It has been considered as the most efficient solution in order to save time. So no central authorities, a direct communication between both civil registers concerned. It might be difficult to organize, maybe, may have some reluctance against such a convention, but it works. It's in force at the moment in 11 states. Exchange of information between these 11 states at the moment. So the system works very well. Second example on a different topic. Second example, another convention concerning exchange of information relating to acquisition of nationality this time. Again, the idea is the same, to give an information about a person. Each contracting state undertakes to inform any other contracting states of acquisitions of nationality resulting from naturalization, option, or reintegration that concern nationals of the later states. I have an information, I will send it to another contracting state because it might be useful for them. Again, you remember, same system, model, forms, appended to the convention. And of course, you know it now, they're plurilingual, so no problem of translation. The form shall be sent directly. You have 3 months from the date on which the acquisition of nationality takes effect. This time the system is a little bit different because you will use central authorities in each contracting state. So no direct communication, but a central authority for each contracting state. And finally, the third example. The third example, convention number 9. Very important one. It's a symbol of our different conventions. One of the most important symbols. Why? Because there is here a use of a very special methods. It can be called an intervention competence. So it's convention number 9 concerning the rectification of civil statutes record this time. The idea is completely different. Before, in the other conventions, the idea was to send an information to other contracting states. It's very useful. This time, we're going one step further. The authority of a contracting state, which is competent to take a decision concerning rectification of a civil statutes record containing an error drawn up in the territory of that state, shall also be competent, and this is the key point, to rectify by that decision any reproduction of the same error in the record concerning the same person or his or her descendants drawn up subsequently in the territory of another contracting state. This is really very important. It means that the French authority rectifying an act is also competent to rectify an act concerning the same person, concerning the same mistake in another contracting state, for example, in Italy or in Switzerland. It's an intervention competence. How does it work? The decision shall be enforceable without any formality in the territory of the other state. To that end, of course, it's always the same system. The competent authority of the state in which the decision was taken must send a copy of the decision and a copy of the rectified record to the competent authority of the state in which the decision has also to be implemented. I have rectified an act. I will send the whole information to the authority concerned in another contracting state. And the consequences, you'll find them in Article 3. When a decision concerning rectification of a civil statutes record has been taken by the competent authority of one of the contracting states, transcripts of or annotations referring to that record in the civil statutes registers of another contracting state shall be rectified accordingly. Merely upon presentation of a copy of the decision concerning rectification and a copy of the rectified record, as we have said it just before. It's a very efficient way to deal with such problems. And here again, you have the different authorities concerned for each contracting states. You will need the different contracting states, they will need to tell to the General Secretary which authorities are empowered to send or to receive such documents or notifications. And there is an appendix in the convention. Of course, it's our work to actualize all these different questions, all the different authorities. There may be some changes in the contracting states and direct correspondence. You see, intervention competence, it's not really easy to admit because civil statutes very often concerns sovereignty of a state. But that system works even if we have only a few contracting states. It works because that convention is in force in 7 states. It means that it might be used in practice. It might give some concrete results. Thank you very much. That's all for today. I hope that I've given you an overview of these 2 crucial points also for the activity of the ICCS. And remember, you may find some information on our website and on Twitter also. Thanks a lot.
Well, thank you again, Professor Nord, for this very, very clear presentation. Again, I myself am very impressed with the practical point of view, the form-orientated convention. For us, it's very new. I would just like, before handing the floor to Professor Nadia, to acknowledge the presence of our international colleagues, especially Professor Guilherme Palau from Valencia. Thank you all for being here with us today. And well, as I've said, we've mentioned, unfortunately, this is our last meeting. And we've been so interested here in these issues, and they're so deep, and these meetings have been so productive. We've been very lucky to have different points of views, but today we're having this exceptional professor with us, and should be able to, as I mentioned, to have a point of view that stands from the academic and the practitioner point of view, and also from the Hague expertise that she gathers. So, Professor Nadia, please, we're delighted to have you here.
Thank you. Thank you very much, Maria Rosa. It is an enormous pleasure to be here in this conference, and I thank Professor Maria Rosa, longtime friend, for the invitation of IDP, and also Professor Nord for his interesting speech with this extraordinary array of information. It is a lot to take in, and I don't know how much of that I'll be able to discuss. I have a really broad experience, not only in academics, but also as a lawyer in the last 10 years and as a negotiator for Brazil in the Hague, the HCCH, the Hague Conference. It seems to me that all these ICCS documents are very down to earth and certainly help day-to-day people. And maybe because you are a smaller corporation type of framework, and the national heritage of the contracting states are not too far apart, it seems to me that your convention were not obliged to make a lot of compromise in their text. I see in the HCCH every day, every single line is a problem to achieve consensus. They are around now, I think, 84 countries, but in a negotiation, there are also observers and all kinds of, some countries that are not a party, but want to be there. And every single line and word, it's a problem. You don't seem to have that divide, which is very positive for the outcome. So from what I've seen in your slides, your articles are very clear. And that is a very good thing for international law. And I've been discussing a lot lately on the methods. The conflicts of law methods interest me very much. And as you all may know, we can trace the origin to the Statutes in Italy in the 12th century. And in the last century, everybody wants to get away from the conflicts of law system. But somehow nothing they propose seems to work. I do know that conflicts of law rules are very technical and difficult, but still a path that shows a result that people can rely on beforehand. And that's, for me, is very, very important. And with the new systems they propose, the more type of substantive approach, you never know what would come out. And you'll be, as a person, on the hand of the judge for whatever result he thinks might be better. So as a person, you cannot know beforehand how to prevent, how to foresee your future. And that's what I think is very important in your conventions. Professor North mentioned that the convention deals dealt with 3 areas. I'll be more in the conflict of laws and substantive law. The state cooperation is very good for every day, but it's not my main purpose. And I have a million practical examples of everyday problems that arise for simple people and that cost them a lot. Every time somebody from one country immigrates and they arrive, it's like their baggage of civil rights is not very clear. Like their birth certificate, their marriage certificate, what is that valid? I know the Apostille Convention of the ICCS has done an incredible work of helping all this information to circulate, but that is really not enough. And especially when you have the birth of a child in another country, the name situation is a nightmare. Even in Europe, I know there are many cases in the European Court of Human Rights because people from Spain, when they have a child in the Netherlands, the way the name is registered, it's a complete fallout of their family situation because of the order they put the forenames, the surname. So it's a very important issue for the families. They feel they do not belong if their names is not correct. They can have a real problem in their country of origin with this child that has a name that doesn't show right away that they belong to the same family. So I see the value of your conventions. And for example, you said that Convention 15 for the record book, I love forms, something that help you every day with registrar. And it can be a nightmare for foreign migrants, especially because all of this is very costly and registrar do not help people. I think even they hate people. I think they hate when somebody comes to them and asks something that's not on their book. And in Brazil, we are from a very registrar type of country. And I have been dealing with small issues like that, like a letter in a surname of somebody who was born in another country. And somebody made a mistake because they don't know the language so much, they don't hear that so much. And in order to register that person in their country of origin, it is a big problem. In Brazil, just to give you an example of how it works, I think our Minister of Foreign Affairs has made an incredible job of putting up all this information in the web in every consulate around the world, because that's the people they see every day. Person migrate to the United States, they have a son, they register it. If there's a problem with one letter of the name, and then they have to go to the Brazilian consulate there to have it registered, and then the person, that child will have Brazilian nationality. It's a very important issue. But it's not over. They have to get that document and still register it in Brazil. It's a 2-3-way step thing, and it costs, and it's not easy. I've been doing that for clients every day, and it's very bureaucratic. Doesn't mean anything, but it doesn't work because the documents don't have a life of their own. They need to pass through all the stages and in every country to give you the rights you deserve. And it's not uncommon to have these situations arise when somebody dies. And then you have to kind of go back and register everything behind the birth certificate, the marriage certificate, the question of matrimonial regime. That's a life on its own. In Brazil, if you married, your marriage certificate will have it written down, the matrimonial regime you choose. That's not common in common law countries at all. And then there's this question of private international law, which is the matrimonial regime of the couple. That if we had a form that if you had a marriage certificate that would be valid worldwide in the same way, in the same form, everything would be so much simpler. So I see the big value of your conventions, and I have a few questions for you, like Convention 19, if it applies to children. You said that that applies to the name of the person, and I wonder if that would apply immediately to a child of that person. That's for later. And I would add, I think the aim of these discussions is to see how we can cooperate in the future. And from my point of view, instead of going kind of country to country, because I've noticed that a country that is not part of your organization could eventually adopt your conventions. But in every country, adoption of conventions, and I tell you my experience in Brazil, it's not easy. It's not easy, especially with very technical conventions, because it's like the government is not very interested. There's not a political stimulus to get it. And then you have to go through the executive branch. You have to send it to Congress. It has to come back to the executive branch for ratification. It is a very burdensome process. So to go state by state, it's not easy. So I was thinking of Latin America, we would have two ways. First, we have, although it's not having new conventions at this point, the OAS has sponsored the CDIPS, the Inter-American Convention of Private International Law. That was a way to try to renew the Bustamante Code. The Bustamante Code, the 1928 Bustamante Code with its 400 articles, it's enormous. And they had this problem with domicile, nationality, and they talk about personal law, so they never solve the conflicts of law problem after all. So in the 70s, the OAS tried to redo kind of the Bustamante Code, and instead of redoing it, they decided to go step by step, case by case, more in the way the Hague Conference does. So if you look at our conventions, we have now 21 or 22 conventions, and they look very similar in a way to Hague Conventions. But in my belief, they're kind of out of subjects in a way, big subjects. So they could go into what we may call small subjects, but they're not small subjects after all, because they're very technical. And we could have some way of working together with the OAS, and instead of going through all the process of a new convention, seeing if a convention of your organization serves for the Latin American countries and enacting it for everybody. They've done that with the Hague Conference, and today they're trying to work together so as not to duplicate the work. So that's an avenue. Another avenue, a more regional avenue, and maybe a good start, a good test drive, would be Mercosul. Mercosul is an organization of 4 states: Brazil, Uruguay, Paraguay, and Argentina. And it has an associate states as Chile and Bolivia. And they have enacted a few protocols on private international law, especially in judicial cooperation issues. And because the aim is, like in Europe, to have a more free boundary type of integration, of course, for everyday person, there's no integration if their documents do not travel well. So that is an avenue, and Mercosur could benefit, again, instead of having a whole negotiation process starting from zero with these issues, seeing if there could be a group study or something to see if this one of two convention of, you have to do this work for every one of them, but which conventions would suit us best to adopt in the 4 countries and see how it goes. Mercosur is a group similar to your group in the sense that we're all from the civil law tradition. We all have this tradition of registrar, notaries. So it wouldn't be difficult for us to understand how your system works. While some countries in the common law world that do not have this tradition of this power of the documents of the registrar so clearly, they may have more difficulties. So in the OAS system, although mainly most of the countries are from the civil law tradition, we still have the United States, Canada, and the Caribbean with common law traditions. So it's a little harder to enact these documents more quickly. While I think if you start with Mercosur, it's a very good test if this way of cooperating would be well translated. So I guess this, I don't want to be here on the floor. I want to hear you about some more practical matters if you give us examples and all that, but that are my main ideas. Thank you. Maria Rosa, I think you can give him back the floor.
Well,
And for everybody
Professor
that
Nord,
wants.
yeah, I think Professor Nord can give us some insight, but I do agree that the approach, the regional approach, seems a more effective way of entering or having having the ICCS conventions entering into force in Brazil, because as we've seen, the issue isn't lack of conventions, really. Very much the opposite. We in some ways fear overlapping conventions. But then again, your system, as it's been shown, the form system, the multilingual vocabulary issue, this practical approach would do us a lot of good. And in this sense, it does seem more appropriate to try an approach that exceeds Brazil itself. We've had, as we mentioned the previous conventions, we've had experiences with the Hague Conventions that were in some ways very frustrating, in the sense that we took some 30, 40 years, Nadia will know it by heart, I don't, to have the Apostille Convention entered into force. So it's just as Nadia's mentioned, to have implemented this convention took so much efforts, and the Mercosur system, not like the European, the Mercosur system is a traditional international law system. So every state has to go through the passes to have the convention enter into force. I would say it seems more clever to have it done with the Mercosur arena. And then again, Nadia is a Mercosur arbitrator. Is that it? I think she would be the perfect person to walk us through this. I don't know if Professor Nord has something to add.
Yeah, maybe we could give the floor to our two representatives of Belgium, just to have their feedback concerning practical questions, if these conventions are working well in their own country or not. I think it would be interesting if Mrs. Boinanx or Mrs. Falis could give us some elements.
I could just explain a little bit, but Belgium is not the first convention you talked about. Belgium is not part of those conventions. It's not entering into force in Belgium, so we don't have a lot of explanation to give. But Belgium is the last two convention. Belgium is those conventions are ratified by Belgium and they are in force. But I don't know, Margot, if you want to give some explanation more. I'm not super expert, but I don't know.
Yeah, it's the same for me. I don't know very much the practical working of these conventions. We mostly know about the convention number 16 with the multilingual form, so that's the one we use the most, and it's very useful. But these ones that you talked about today, I cannot give a lot of practical informations.
But
Sorry.
if you have specific question, we can always ask to other actors of civil status, and they would give a full answer. So I think maybe it's better for you if you have specific questions. We can also always ask someone who's more into that subject specifically.
Yeah, just to maybe one more element about the efficiency of these instruments. You must know that in Europe, we have now a regulation concerning circulation of public documents. So there is a competition between our instruments and that regulation. And we have some brand new studies. We received them last week only concerning some concrete figures about the use of the regulation and the use of the ICCS conventions. And we see very clearly that the contracting states parts to our conventions are still using them. Why? Because they are much more efficient than the regulation. The practical approach, again, is much more satisfying, and the different authorities are really familiar to our instruments. So there is no concrete change. For example, we have the experience of the Netherlands. In some cities, the regulation is not used at all. So in very big cities, international ones, they are not using the regulation because they consider that that regulation is not really satisfying for the needs they have. So our conventions, because they reflect the practice, are much more efficient at the moment.
Well, that's a very interesting point of view, and it is something that actually happens here in Brazil too. We have overlapping conventions, and choosing which one to work with is sometimes very demanding. Explaining to judicial authorities that we as civilians have the right to choose and manage these different conventions. This is a work in its own. But going back to Professor Nadia's suggestion about Mercosul, and it wouldn't be adding another level of convention. It wouldn't be adding to this overlapping. It would be more in the sense of introducing your form system, for instance. The form seems very, very interesting, and it's something that we lack. I think Nadia would have something to say about that. The operational procedures with the forms seems very, very efficient, and we do not have that neither on CDIPS nor in Mercosul nor in any convention that I can remember.
Well, in CDIP, for example, in the service of process, we do have a form that is what it's used. It's very helpful to have a form in order to have all the information you need when you send out a request to serve somebody in a foreign country. And also in the Maintenance Convention of The Hague that we are now a part, there's also a very interesting form for the central authorities to ask the other country. And that's extremely important for everyday use, because at the end of the day, it is not the professors that work with these conventions, is the people who are in the registrar, the normal people, and they do not have like a very good understanding of conflicts of law rules. All they need is a form that they have to follow and to solve the problem. They have people on their balcony asking them questions all day long, and they have very little time, and they need to be efficient. So if they have a form that states everything they need, then the problem will be solved. While if they have to ask themselves where to go and how to do certain things, they would just put it away and not do it. These people that work in registrar, they're very bureaucratic. They're very afraid of making mistakes because they are liable for their mistakes. So if they have a certain form that gives them very clear instruction on how to perform, that will go well. While if they don't, they'll just don't do it. Just don't do it. And people, I've seen people, I have clients that come to me for very simple things, just for registering their marriage. That's something that comes up all the time. Somebody marries in a foreign country, they have this marriage certificate, and it doesn't travel. They don't remember to apostille it when they married. They don't remember. In Brazil, we have a rule in our civil code that every Brazilian who marries abroad must register for publicity their marriage abroad in our system. Although there's no sanction, that is something that is mandatory. And people don't know what to do. And I have people come to me and say things like, oh, you know, I've married in the United States, but because I didn't register, I'm single in Brazil. I said, there's no such thing. Once you're married everywhere. There's no such thing as not being married because you have not registered your marriage. Although the authorities may not know you're married, but you are. You're just a liar. It's just a lie that you want to go being single in one country and being married in another country. And it's bothersome for people to go, and so they marry and they have to go to the consulate. And the consulate, you need an appointment and you need to come with a certain documents, and you get there and you don't have all the documents and send you away and you have to have another appointment, it takes a while, and then once you have that, it's not complete because you have to go to your country and register. I had a case of a person who had 3 children, and he was living in the United States. He registered the birth of the 2 of their sons. And then with the daughter, he was in another city, Boston or something. And the registrar at the consulate said something because he has changed his name because he obtained US nationality or something like that. And he went to the consulate and there was a device between his name and the name in the birth certificate. And the consulate just didn't register. It said, oh, there's inconsistency. You have to solve this before. He got the wrong type of juridical consultation. And he came to Brazil and registered his daughter here directly. And it happens that in our constitution, if you're born abroad and you register at the consulate, you're national. If you're born abroad and you register only in the country, after 18, you have to do another reaffirmation of your nationality. So you're not a national. And for that, you need to be a resident, which may be a problem. So see, somebody who had parents that were careful the moment they were born to register them in the consulate, they could be president of Brazil because they're Brazilians full. While the second case, they have to come when they're 18 and start an action at the federal court to affirm their nationality. And they have to prove they live here, at least for a while they're requesting it. So this is just ridiculous and this is part of problems with registry and appointments, and all depends if you live in a city that has a consulate and another that doesn't. For example, the United States is very big, and you have 8 or 9 Brazilian consulates, but not everywhere. I can say that from experience because I was the one to say to my daughter, we have to register my grandson. We have to go. She lives in Orlando. She had to have an appointment, personal appointment, even in the pandemic, in the consulate of Miami. I went with her. She took a day off. She went there and she was saying like, why do I have to do this? I said, you must, we're gonna do this. But if you don't, then 20 years later, your son is not a Brazilian national, doesn't have the passport. You have to start all over. So I see this every day, and I see the merit of a simple convention that has a form and that everybody knows and that works well for the bureaucrats. Maria Rosa.
I think
Up to
Professor
you.
Nord has something to say.
Yes, just to come back to Mercosur, I think that's it's the right level, because as we mentioned it in the 2 last sessions already, you need to trust in each other. So the different contracting states must be in that relationship. We need to trust in you. And if there is already a more general framework, I think that our conventions could be very useful for you. And of course, we are at your complete disposal if you want to know more about our conventions, or if you want us to organize a presentation to any kind of authority. We are at your complete disposal with much pleasure.
Thank you. I'll see how we can do, as I don't know if Maria Rosa mentioned in the beginning. Currently, I'm an arbitrator for our Court of Revision of Mercosul. Is not the right place for sending this kind of proposal. I think the Ministry of Justice meeting is a better place, but it doesn't mean that the court cannot have a say and propose something to the countries or something like that. So we'll have to see how we can work this out in the future. It will require a few studies, technical studies and presentations, and it would require a group with professor or something from each country to see if there are if it's compatible with each of the 4 countries. But we have a very good network of that in ASADIP, the meeting of professors of private international law in Latin America. So it's not difficult to set up a small group interested in this point. I'm a very practical person. I always think of the practical steps. So that's how I think it could work.
Perhaps we could profit from this meeting and start. We have a research group here in IDP. We could have this research group working with PUC.
Yes.
Under Professor Nadia's orientation, we would have this IDP group, the front group. I think Nadia's been formally invited. If not, we'll formally do this, and we can exchange some ideas about which conventions and how to do this approach. We have the possibility of sending this research results to ASADIP and other organizations. We could have Professor Guilherme Palau from Valencia and Gustavo Cerqueira, who unfortunately isn't here. But
yeah,
I think this would be a splendid result to have this.
Yes. ASADIP has a meeting every year in November, and we can present a paper on this issue. And certainly it's not hard to have, we can have Cecilia Fresnero from Uruguay, we can have I know a few professors from Paraguay and also Labrano and also Maria Blanca from Argentina. So it's easy. People who are interested and are very aware of how Hague Convention works. So people who are very into studying how these conventions of other type of issues work. And at PUC, my dear colleague, Daniela Vargas, is a very good addition to this group. She works extensively with nationality issues and family law issues. So I think we should, but I think the supervision should be Maria Rosa. I'll be a guest. Maria Rosa and IDP, and we can make a joint project or something like that. And see, first thing is to have like a task force and see which 1 or 2 conventions we would start with. You have a very long list. It's not easy to tackle all of them, but I think we should start small to see how it goes.
Well, great. We'll have a joint orientation, Nadia. Professor Nord?
Yes. Of course, the General Secretary is at your complete disposal if we can help you in your researches. If you need some concrete informations about our different instruments, about their practical use, we can always help you and are at your complete disposal. I think that's we could make some concrete proposals also with our president about the way we can exchange about all our instruments. So don't hesitate, of course. If you need anything, just tell us.
Okay. Thank you. So I think we reach the end of our final meeting. It has been really a great pleasure, and it's been a special joy to be here with you, to have our Dean, Professor Schertel, with us today, and this correlation of events. I would just thank you all again. I would like to mention again that this webinar was a work of Professor Gustavo Cerqueira, and I would like to thank him again. Unfortunately, he couldn't be with us, but next time he will. I would like to thank very, very much Professor Nord and his team and the whole ICCS. Thank again Professor Nadia for always being so easily available when we know her agenda is impossible, but she always answers us with very, very high thoughts and great insights. And especially thank Professor Ardeen, Professor Schertel, for also being available when we too know that his agenda is very, very tight. And so I think we reached the end, but we've compromised in this group that will be the follow-up on this work. Thank you all. It's been a great pleasure.
Thank you very much. Thank you for the invitation. It was a real pleasure to have these sessions with all of you. Thanks a lot. Hope to see you soon, and not just on the screen.
Yes. Oh, we have to have a meeting in person in Europe. Yes, we're longing to travel.
Yeah, I would just like to complete the words of Professor Maria Rosa, and also use the last words of Professor Nord. And we also like to say that we would very much like to receive you, Professor Nord, here in Brazil when you have time. And we would, and of course, Professor Nadia also in Brasilia, and also other Margot and Chloe. So we hope that the world finds a way out of this crisis. And we, as I said, we Brazilians love to receive, and we at IDP are investing a lot of our resources in this international connection and building. Brasilia is an international city, and we like to foster this side of Brasilia in the academic sphere. So please feel invited, and we hope Maria Rosa is the best person to do this contacts. But if you have any thoughts or any idea in visiting Brazil, please feel free to contact us. We will surely try to do our best to make any project or any visit or any travel possible. So thank you all. So it was a great pleasure, and I learned a lot, as I'm sure all the persons here have done too. So thank you very much.
Thanks a lot. See you soon then.
Thank you. Bye.
Thank you. Bye.